A question that many people face is whether they should accept a plea or go to trial. In this video, we're going to talk about the many factors that go into making that decision as to whether or not you should accept a plea or go to trial. A question that a lot of people have to answer for themselves is whether or not they're going to accept a plea or go to trial. Going to trial is a massive decision for a person to undertake. It's certainly a valid position to take, to say, I'm either going to get this case dismissed or I'm going to go to trial in a number of circumstances. One of those circumstances is certainly when a person is not guilty. So if you come to me and you say, Benson, I didn't do this, they're accusing me of doing this, and I'm not going to accept anything, I will wholeheartedly fight for you and accept that position because you shouldn't plead to something that you didn't do. Nonetheless, we will always talk candidly about the possible decision of going to trial. That generally won't be at the very beginning, because even if you come in and you say, the only thing I want is a trial, the reality is in courts in North Texas, setting a case for trial means you're going to be waiting 12 to 18 months. So there is a pre-trial period, whether or not you want a pretrial period. And during that pretrial period, there will be negotiations. And so in a situation like that, I would be negotiating for a dismissal. How can we convince the prosecutor that this is not a case that they should move forward on? As the case progresses, if we're dealing with a prosecutor who's not willing to listen to reason or persists in their disagreement on what the case is actually about or what the merits of the case are, then we'll get into a situation where we're talking about the risks and rewards of trial. And there are a number of things you'll be thinking about as you think about the decision to go to trial. First, we're going to talk about the strengths and weaknesses of the case. In any case, we're going to talk about what elements the prosecutor has to prove in guilt innocence. And of course, being a criminal case, most of those elements have to be proven beyond a reasonable doubt. We will talk about what evidence the state believes it has and how we're going to counter that evidence, whether it's going to be through cross-examination, other witnesses, potentially your own testimony. And we will give you a prediction of what we believe jurors in this area will do. We will also talk about the possibility that 12 jurors in a felony case or 6 jurors in a misdemeanor case get it wrong and they convict you. What will happen if you're convicted? We will move into a punishment phase. We'll talk about what the possible sentences are. We'll talk about the collateral consequences of losing. We'll do all these things so that you can make an informed decision, because as much as we're taking a position that you're not guilty and we're fighting for a dismissal, you can't go into a trial without knowing and being prepared for what could happen if we lose. You also have to understand that very few cases actually go to trial. To put that in perspective, last year in Texas, 227,655 felony cases were filed. 2,274 felony juries were seated. That's less than 1% of cases that actually get to a jury trial. In Tarrant County, it's even a lower number, at 0.079% of cases making it to a jury trial. So why would you set your case for a trial if the chances of getting to a trial are so low? Well, many more cases than are actually tried get set for trial, and there are a lot of reasons for this. First, it puts pressure on the prosecutor. It forces them to really work up their case and evaluate their case better. Setting a case for trial may be the first time prosecutors talk to witnesses other than the alleged victim. They might start to see what you've been telling them for a year or 18 months, that there are significant weaknesses in the case, that there's a chance that they'll lose the case. You also want to set cases for trial based on what court you're in. For example, if you're in a court where you know the judge is going to give you a fair trial, or, for example, in misdemeanor cases, if you know that even if you're found guilty, the judge would give you a lower sentence than the prosecutor is willing to agree to, well, that might be a reason for you to set the case for trial. There are a number of reasons a person may want to go to trial. First, they didn't commit the offense that they're accused of committing. Second, they don't agree with the punishment that the prosecutor believes is appropriate on the case. Third, they can't live with the collateral consequences of a finding of guilt. So for example, if you're a pilot and you're charged with driving while intoxicated, you may have to go to trial to maximize your chances of avoiding a conviction so that you don't lose your license and therefore your livelihood. For some people, it's just a personal choice. They feel what they did, whether it was actually criminal according to the laws that we have in our state or not, that they were justified in doing so. So they believe there might be an affirmative defense that a prosecutor is not accepting, but they hope a jury would be willing to listen to. Ultimately, as you're contemplating going to trial, it's very important that you sit down with your attorney, you go over all the evidence, you go over the strengths and weaknesses, you go over the direct consequences and collateral consequences of a possible finding of guilt. You prepare for the guilt innocence portion of the case where you're fighting about whether or not you're guilty, but you're also preparing for the possibility of a punishment case, because you can't bury your head in the sand and say there is no risk to going to trial. And if you go to trial and lose, it will at that point be too late to start thinking about who am I going to put on in terms of punishment so this jury doesn't send me to prison, so that I can still stay out, maybe get probation, for example. Finally, you need to talk to your attorney about who the judge is in that court. Understand the judge may or may not preside over your case. The judge may have a visiting judge come in for the week of your jury trial. But to the extent that you can, you need to talk to your attorney about how does this judge operate? Does the judge call balls and strikes fairly? Does this judge give both sides a fair shake? Does he allow for fair cross-examination? Or is this a court where you shouldn't go to trial because the judge is going to favor the prosecution? You also need to talk to your attorney about the jury pool. What kind of jurors show up in this jurisdiction? How many cases has this attorney tried in this jurisdiction? Those are all questions that you need answered by your attorney and have a discussion with your attorney about before you finally answer the question of, do I accept a plea or do I take this case to trial? Thanks for watching this video. If this content was helpful for you, be sure to like, subscribe, and hit that notification icon. You can also find us online at versus texas.com.